I come from a fairly unique perspective, having tried patent cases and did patent litigation for 17 years. I don't have a technical background, but that's neither here nor there, because I tried patents in all different kinds of technology, and I don't know what technical background would have necessarily trained me to do the biotech cases and the electrical engineering cases and the semiconductor chip manufacturing cases. But my colleagues still laugh about the fact that I'm like, oh, a patent case, yay. And they're like, ooh. But I have a higher opinion, I think, of patent lawyers than a lot of my colleagues in terms of, I think you all work very hard. I think you're very smart. I think you do your best. And you have the resources in most cases to litigate hard and make people work for their cases. But I don't necessarily think that that sort of overlay that you hear of, oh, they're just trying to run the bills, is fair. I would trade a patent case for a pro se 1983 case any day of the week. But, it makes it interesting for me because to some extent, well, you always have to stay current and the law is evolving, and we're going to talk about that. At least I've got the fundamental basic understanding of the patent law, and so I just need to get your technology. One of the things I wanted to bring out about this, though, is that you all need to appreciate what we do every day in terms of the breadth of what we have to do. I was looking at my numbers before we came up here, and I currently have 220 civil cases on my docket, 37 of which are patent cases, and about 350 criminal matters. Southern District of California has one of the heaviest criminal dockets in the country. I don't do any pharmaceutical cases. The only cases I have with drugs are in the trunk of somebody's car. So, know your audience. If you end up in the Southern District of California on a Hatch-Waxman case, you're going to be at Patent 101 because we don't do that there. We do biotech and we do medical devices, but we don't do any pharmaceutical cases there. So 15% of my cases are patent cases, my civil cases, and the other 85% are, they're antitrust, they're securities litigation, they're class actions and labor cases, they're ERISA cases, they're maritime admiralty cases, they're civil rights cases, 1983 cases where the plaintiffs write in crayon, and they're diversity cases for every kind of state law claim that you can think of. And so not just day to day, but hour to hour, your mind is doing this shift from one topic to another. And while I really appreciate that lawyers think we're brilliant in whatever it is they're in front of us on, sometimes we're not. And you need to be prepared when you come into court to teach us in a non-condescending way to make sure that we know what's going on in your case, because you've been steeped in this litigation for a long time, and I'm walking into it after I just finished a suppression hearing on whether or not your cell phone needed probable cause, and now I'm looking at, whether or not you've, whatever your claim construction issue is. And so, it's exhausting sometimes.
It's exhausting listening to you. Well, Judge Hochberg, if I can just,